All right. Just a second. Okay, I think I'm ready now. Sorry, I was on a different computer and it was giving me feedback. So thank you all for attending tonight. I've got that it's 5:59. Again, some housekeeping for any agents that have anyone watching with you. Just let me know the count of how many folks are watching, and we'll get that count hopefully to everybody probably in the new year now that we're here at the end of 2022. This is our last session, and we appreciate for everyone being on tonight because I know there's a lot of holiday things happening. So at this time, I'll go ahead and turn it over to Philip.
Thank you, April. We got with us again Mr. Luke Bentley with Luke Bentley Law Offices. You've been in the business for a while. Before we get started with tonight's presentation, Luke, I had a question that was emailed to me. Last week, you mentioned talk to the lawyer, talk to the insurance agent, talk to the financial advisor. What if you do that and they give you three different answers?
Very good question, Philip. First of all, let me thank you once again for the opportunity to be here and speak with the folks, for those who have joined us here this evening and those who are joining us virtually. That's a very good question. I can tell you that very oftentimes you might even find a circumstance where even one of those professionals might give you more than one answer. As a lawyer, many times when I'm discussing issues and situations with clients, they're often looking for the answer, and the best I can do is give them options and a range of answers, and then it's up to the individual to decide what's best for themselves. But more particularly with your question, deals with a situation where you are engaged in your financial, your estate planning, you have your financial advisor, you have your legal advisor, you have your insurance advisor, and you're getting somewhat conflicting advice from the three of them. I wish there was just a simple answer to that, and there's not. I think typically what I would tell a person is to evaluate or weigh those answers based upon the area of expertise that the question is directed toward. And I think the professionals would each tell you the same thing. I think we tend to like to stay in our lane, so that if it's a financially related question, a tax related question, obviously that's going to fall in the area of the financial advisor, and of course the legal process and documents would be more in the legal realm. But it's just going to end up being what the individual feels more comfortable with. It might be the person you know and how their advice comes to you. So unfortunately, there's not a real straightforward answer to that. And it does oftentimes happen that there are some different answers that you get. But I guess it's kind of like going into a restaurant. Sometimes the menu has a lot of options for you, and you'll have to decide what's best for you.
That's a great answer. Well, thank you, sir. Well, tonight we're going to finish up our end of the series, and we're going to talk about, what are we talking about? End of life care and funeral expenses.
That's right.
Mr. Bentley, I'm going to turn it over to you, my friend.
Thank you, Philip. And thank you and all the folks here at Lewis County who are always most helpful and have taken their time to help me to get this presentation set up, because the technology end of it is certainly not that is not my expertise. Well, tonight we are going to talk a little bit about end of life care and planning, as well as how your final expenses, your funeral expenses, can work into your estate planning as well. Again, let me just say at the outset, I guess, give the standard legal disclaimer that what I'll be discussing with you here tonight, what I'll be sharing with you, is not legal advice. You'll want to consult with your own professionals, your own advisors to give you specifics because each situation is different and can result in some of those different answers, Philip, that one may get. So rely on your own advisors to give you your specific information. But what I do want to do is to share with you some of the general topics and issues that we all will be presented with when we come to that point in our lives. We'll look at some of the specific laws and statutes that the state of Kentucky has implemented and has in place. And also just to touch on briefly as we conclude this evening, some of the proposed legislation and newer elements of this area of law that are on our horizon, and we'll see how that plays out as time goes along. When we talk about end-of-life care and planning, of course, this is not really a very pleasant issue to talk about. It's not one that an issue, a topic of conversation that often comes up at cocktail parties or Christmas gatherings or kitchen table talk. But, you know, it is the one aspect of life that we all do have in common, that at some point we are all going to reach the stage at which this life is not going to continue on any further. And for most or all of us, we do have loved ones, we do have some property or things that matter to us that we want to dispose of, and what we would refer to as a legacy. Sometimes those words like that can make us think of rich and powerful people, but all of us have a legacy of some sort that we do want to leave to our family, to our friends, to our community, or whoever that is. And so when we reach that stage, is oftentimes the point of our life to where we come to realize that the end may be a little closer than what we have thought about in our past. Those questions can present themselves much more forcefully to us. Sometimes it can come through a medical diagnosis that lets us know that the end is closer than we may have thought. Maybe an accident or some other thing beyond our control that may push those issues to the forefront a little quicker than we thought. But whatever the circumstance, our end of life planning, and especially those who may be in a situation where they are looking at the end of life care, while those issues may not always be easy to address, they are certainly some of the more important that we will ever have to deal with. And from a very realistic and pragmatic standpoint, the idea of preparing for the end simply means that what we're doing is making easier what could be a very, very heavy burden for our loved ones later on. And of course, the great benefit of planning is that we'll be able to leave behind not only the plans that we would like to see followed, but also what we remove from our loved ones, the decisions they don't have to make, the conflict that does not arise because we have taken time to plan for that ahead of time, can be invaluable to those who come behind us. Of course, we've had you've had here in your estate planning seminars in this series. You have looked at some of the specific things that you would want to ideally have in place prior to the time when that time comes in our lives. The end of life planning, of course, includes things such as your end of life preferences, how extensive of medical intervention and measures that should be taken for you. And though it can feel sometimes very uncomfortable, an uncomfortable part of the conversation, it's a very important part of the overall estate plan. And addressing these issues can even give an individual, especially one who sees that on their horizon, a very real sense of peace once those type of plans and cares put into place. It ensures that your wishes are clear, so that others don't have to guess what it is that you might have wanted to take place at that time. Why is end of life planning important? Well, it does make your wishes official. Some of those wishes, as you've talked about in prior sessions with the various documents, and I'll mention those again kind of in summary here this evening, how they interplay in this. Some of those documents that you put in place make your wishes official, legally binding, enforceable by a court. And other plans, other documents, other aspects of your end of life planning and estate planning in general may not be necessarily legally binding, but they can provide great direction and can be, should we say, maybe morally or ethically binding on those who do want to see that one's family members' last wishes are honored. So preparing now for that inevitable outcome is one that allows us to take at least some measure, some level of control over what can seem to us that we have very little control over. If you're faced with that situation with yourself or a family member who needs to discuss the care of end of life and begin to put those plans into place, there are some things that can help to improve that planning process and those decisions that will have to be made. First and foremost, and probably most importantly, is to have those conversations. And that means you have to talk about it. Sometimes we just assume certain things, or we think, well, the family knows what I want, and I don't know how they would know unless they have some telepathy to read your mind, but we just don't want to talk about it, so we hope that they'll figure it out. But that's oftentimes a recipe for disaster, that the failure to plan in those areas is what forces so many families into conflict, into court, when that's not necessary at all. The conversations will be hard. They will be difficult conversations, but it's the most important part of the process. And it becomes even more essential and perhaps pressing if that conversation is because the individual has received a recent diagnosis of some terminal medical situation or things of that nature. In having those conversations, it's a really good idea to plan out what you want to say, to make yourself notes so that if it does become emotional, you'll have the resources there to help guide you in that conversation. There are actually some resources online that you can search for and find some various legacy sites that can give you checklists and outlines that will help you engage in those conversations. Sometimes it's very good to even have a manner by which you can record some of those conversations, just for the benefit of those who will have to be left with making those decisions later on. It's good to engage completely, to be honest and forthright, dealing with those difficult issues. Typically, it's best to remain matter of fact, to not, to as much as you can, to leave the emotional side of things for another time, and just to keep the conversation at a high level, very fact-based, as if you're talking about any other important issue or decision that has to be made. It's important to remember to be very respectful of all that are involved, whether it's the individual's life that is under examination at the time, and also for those who will be making the decisions and acting in the capacities of legal agents or representatives later on. They all deserve respect. And I think it's important, finally, to the extent you can, to put those wishes in writing. Of course, we know that the legal documents are in writing, the will, trust, powers of attorney, those things that I'll briefly mention here this evening. But even the more personal things or plans that the individual would like in their care, or after they have passed, how their funeral arrangements or their celebration of life activities will be. Having those in writing will be very helpful. And as with any estate planning process, it's important to keep to check in on that after time goes by. Of course, if it's an immediate need, that won't be necessary. But if time goes by, thoughts change, ideas change, and so it's a good idea to check in along the way to make sure that the plans are subject to whatever changes that you may have made. So here are just some of the things that at whatever stage that a person may be in prior to the end of their life, that are important to keep in mind. One that you've spent time here talking about in your various sessions is to make sure those end of life documents are complete. That is very important. It's sometimes very easy to feel a bit overwhelmed with the different documents and aspects, the various professionals, as Philip mentioned, to that all that can feel like it's a bit too much, but really it's not all that complicated. As you've already talked about in previous sessions, of course, you'll want to decide whether you want to have a will-based plan or a trust-based plan in place. There's a common misperception that trusts are only for the very wealthy, and that's not true at all. The reality is that anyone who owns property or assets of really any value can consider a trust. Not only do trusts protect you and your loved ones and your legacy once you're gone, they also offer privacy and allow the transition to take place oftentimes in a very much more friendly and easygoing environment than what the probate process for a will would take place. A will-based plan is often simpler, and a trust-based plan somewhat more complex, but it's not that much more difficult. A key difference between the two is that a will-based plan won't take effect at all until the individual has passed, whereas a trust goes into effect as soon as it's created and can have can have actual benefits while the individual is still alive. As soon as it's created and funded, as soon as the assets go into the trust, then it's operative and continues to be so as long as the terms provide. The will, of course, can be used to specify who you want to receive your property after you pass, including your physical assets like your home, your vehicles, and your possessions, your financial assets, your bank accounts, your investment accounts. It can name the people or organizations that you want to receive your property, the beneficiaries they're called, and it streamlines, having a will streamlines that process and makes sure the assets go to the people that you want to have them. Also, with a will, you can name guardians for your children or for others who may be incapacitated that may be necessary. Also for your pets, maybe you want to have provisions made for your pets. I'll mention that here again here in a second. You can also name who you wish to be the executor or the person responsible for overseeing your estate plan and distributing your assets. A trust, on the other hand, is a document that essentially gives a little bit of stronger protection if some of these things are important to you. It can give stronger payment control, that is, over the asset distribution as far as controlling when at various ages and stages at which the beneficiaries will receive the assets. It can also provide stronger privacy. Anytime there's a will, that will have to go through the process called probate. There's a saying that says, where there's a will, there's a probate. And that is true. If you have a will, your estate will go through probate. And so a trust-based plan can provide stronger privacy because that probate process is a public process. That means all of the probate documents, which include the amount of property, the assets that are being received and by whom, and all of that is public record and open to the public, whereas trusts are not, and so they can provide much stronger privacy. And finally, trusts can also provide stronger protection. Since your trust technically owns the assets instead of you as an individual, then your estate can be protected from litigation. It can be, if structured correctly, can also provide asset protection for the beneficiaries. That is, those who receive the money from the trust, if it's set up in certain ways, can provide that individual protection from future lawsuits against them, from future divorces that they may be involved in, or future any future claims if set up in that way. Like a will, a revocable living trust is a tool, a very, very useful tool that you can have to manage and distribute your property after you pass away. But unlike a will, the revocable living trust is a legal entity, meaning that it is able to own property in its own name. And the property is transferred to that trust with a trustee who in a revocable living trust is typically the person setting up the trust, who can manage those assets and change it if necessary, or if they decide to do so. Another important step as you consider the end-of-life decisions and end-of-life care are beneficiary designations for what are called non-probate assets. There are some assets that won't go through probate or shouldn't if you designate the beneficiaries beforehand, and those are assets such as 401k accounts, life insurance policies that we've talked about before. Those are assets that are sometimes very large assets that can be administered outside of an estate entirely if they're designated with beneficiaries prior to death. Keep in mind that every institution has their own specific designated forms and documents that are necessary to be completed in order to name those beneficiaries to ensure that that property passes outside of the probate estate. Some other documents or steps that are necessary or important to consider as you face end-of-life decisions are one that I always recommend is an inventory of assets. Many times a family will come in after the death of their loved one, and they just simply don't know what assets the person owns, or they may be aware of some things they had, but they don't know where they are. And so having an actual inventory, a list of the items I own and where they're located, and if they have titles or ownership documents, where those documents are located, that can be invaluable to a family after a loved one has passed. To include things such as your bank accounts. Oftentimes, folks will have bank accounts spread out over half the state in different counties and locations. So a list of the savings and checking accounts, location of cash. If you have a lockbox or a safe somewhere, of course your deeds, land contracts, investments, stocks, bonds, all of that should be listed in an inventory so that your loved ones can know what you have and where it's located. If not, there's a danger that property that can't be found or located or known about is ultimately could go to the Department of or to the state with their unclaimed property, which is oftentimes fun to look on the website and see if there are any if your name is there anywhere. You might be an heir that you didn't even know about, perhaps. But you don't want to lose those assets, so make sure they're inventoried. What's called a durable financial power of attorney is extremely important. With a financial power of attorney, you choose someone to make financial decisions for you if you can't make them yourself. It can include paying your medical expenses or your other bills and living expenses if you're unable to. Filing your taxes, anything such as that. The person you name in your financial power of attorney is an extremely important step to take. And it's called a durable power of attorney. The word durable there means that your agent, the one you name as your power of attorney, your agent's authority continues even if the one making the power of attorney becomes incapacitated. So, for example, if they should be in an accident in which they're no longer mentally alert or in a coma, something of that nature, the power of attorney will continue even if that individual is unable to make their own decisions. And that's the purpose of it after all. Having someone to manage your finances, if you can't, can be crucial to your family. Now, it is important to know that in Kentucky, in the statute, if depending on the time, I may mention these statutes here in a minute, but under the Kentucky Act for Power of Attorneys, having a financial power of attorney does not give the agent the authority to deal with healthcare issues. There is a Living Will Directive Act in Kentucky that has been passed that gives individuals the right to nominate certain persons to make those medical decisions for them. But it has to be specifically done in that regard. The Kentucky Living Will Directive Act of 1994 was passed so that adults who are competent have the right to make decisions regarding their own medical care, even the right to accept or refuse treatment, and that would apply to even the end of life decisions, such as those processes that would extend life, like a breathing machine or a feeding tube, things of that nature, that are covered by those medical powers of attorney. Some of the language that you'll hear in this area are a medical power of attorney, or a living will is a term often used, which is not the same as your last will and testament, or sometimes it's referred to as a healthcare surrogate. In Kentucky, a living will, what's referred to as a living will, allows you to leave instructions in four very critical areas. You can designate a healthcare surrogate. That means someone else who will be making decisions for you and on your behalf. It allows you to either refuse or to request life-prolonging treatment. You can refuse or request artificial feeding or hydration, what is called tube feeding. And finally, you can express your wishes as it pertains to organ donation. And those are all very important aspects, very critical aspects when it comes to end-of-life care and planning. With a medical power of attorney, you choose someone to make those decisions for you if you can't make them yourself. Of course, as long as you are still able and competent, you can make those decisions on your own, but it only typically will only operate if you are unable to make those decisions. We mentioned a couple of weeks ago when I was here, we talked about life insurance, how important that is in considering as part of your end-of-life plan. It, of course, protects the people who rely on you financially to cover the day-to-day, as well as the long-term expenses. And as we'll mention here in a moment, when we talk about funeral expenses as part of your estate plan, it can also pay for those funeral expenses or probate costs. Another aspect of your of the end-of-life care and decisions, planning decisions that can be made have to do with what are called the do not resuscitate orders and the POLST forms. If an individual's health is declining or they're in a state in which the death may be more imminent, then there are these end-of-life care documents can be put into place to carry out your wishes. A do not resuscitate order, what's often referred to as a DNR, tells healthcare providers that you don't want to be resuscitated in the event of an emergency. POLST stands for Physician's Orders for Life-Sustaining Treatment. And that outlines your wishes for end-of-life care, especially in regards to an existing diagnosis. Both of these documents are often used by people with failing health and usually aren't necessary if you're a healthy individual just planning for your estate. But if you are in the more imminent stages of the end of life, then those talk to your doctor, because typically they will have the forms that they use to implement the DNR or the orders for life-sustaining treatment. almost all physicians will work with you to record your wishes and put them on file at their office or the hospital or the hospice facility or wherever you may be. Also, it's important to consider your end of life housing arrangements. It's worth considering where you may want to live in your final days, and to include that in part of those instructions that you leave to the family members, or that you put in whatever plans that you have recorded. For example, would you prefer to live in a nursing home, or would you prefer to live at home and receive care from an in-home caregiver? Perhaps you intend to move in with family members, or want to consider the costs and the aspects, the trade-offs associated with each particular living arrangement. Again, it's important to have those conversations, to talk with your loved ones about your wishes, so that you can ensure that everyone's on the same page and knows what you prefer. Another area to consider, especially in our modern age, is our instructions for your digital assets. I read just the other day that the average person under the age of 70 has nearly 200 digital accounts of some variety, whether that's important assets like bank accounts or investment accounts, insurance accounts, those type of things. Also, our social media, our various accounts that we set up. I know it's sometimes funny to try to keep up with our various passwords and usernames. It is for me. It is very difficult to keep up with sometimes. There are some digital vaults and password managers you can find online that keep track of that. And is also that some of them offer a way to provide for a digital agent to take control of those after you pass. You can name, again, a function of our times. You can also name a digital executor in your will, who will manage and shut down your online accounts after you have passed. In Kentucky, our state legislature has passed a rather comprehensive Digital Assets Act in Kentucky Revised Statute, Chapter 395A. So there's a rather extensive provision for that. And to your credit, Philip, and your other extension agents and employees, in doing a little online checking before I came here this evening, I ran across some really good resources that the university has put together that deal specifically with this area of digital assets, and give some outlines for what it takes to shut down Facebook accounts and Twitter accounts and all that. So that's good to keep in mind, at least when you're considering what online activity you may have. Finally, as far as the things to consider, the funeral instructions and burial arrangements. It may seem a little morbid, but there are benefits to planning your own funeral. It is something that's going to happen, and if you want, some people may want to have input into it, and some may not prefer to not, and that's your prerogative, how you wish. But of course, in any type of planning of this variety, it is going to reduce the emotional burden that you leave on those that come behind. Every decision that you make now is one that your family doesn't have to make. while they are in all likelihood experiencing a time of deep grief. Such basic things in your funeral instructions as to whether you want to be buried or cremated, which is a more common decision made today. What type of service that you would prefer, whether it's a traditional funeral service or later end of life celebration of some sort or some activity or whatever that might be, where you'd like to be laid to rest, and any other of those kind of decisions. Again, you can also choose a preferred person that you want to carry out those instructions. There's even, I've seen online sites that offer a step-by-step process for writing your own obituary. Each individual may have a preference in that. Funeral instructions typically are not considered to be legally binding. However, they are extremely helpful and appreciated by those that come after. And again, they do create at least some sort of moral and emotional obligation on those who are carrying out those wishes. By creating, again, in summary, by creating those end-of-life plans and documents and discussions, conversations, you make that process about what to do with the things you have, the people you love, the health care, and the end-of-life care that one desires to have. Let me mention here just a couple of items that I thought were of particular interest in this area. At least as it pertains particularly to Kentucky and our law in this area. Kentucky has a complete chapter in the Kentucky Revised Statutes. It's chapter 311, which has several provisions that deal with these areas that we've talked about this evening: living wills, directives, medical orders for the scope of treatment, the persons involved, healthcare surrogates, what decisions those healthcare surrogates can make, a whole section on withholding or withdrawal of life prolonging treatment, things of that nature. Specifically, just want to mention when it comes to that issue, KRS 311.629 provides that a surrogate, that is the individual that you name to make your healthcare decisions, a surrogate may authorize the withdrawal or withholding of artificially provided nutrition and hydration. So that's food and water. May authorize the withdrawal or withholding of artificially provided nutrition and hydration in the following circumstances. One, when inevitable death is imminent, which for the purpose of this provision means when death is expected by reasonable medical judgment within a few days. That's number one. Two, when a patient is in a permanently unconscious state, if the individual has executed an advance directive authorizing the withholding or withdrawal of artificially provided nutrition hydration. Or three, when the provision of artificial nutrition cannot be physically assimilated by the person, they can't take it in. And finally, number four, when the burden of the provision of artificial nutrition and hydration itself outweighs its benefit. And so that's what's provided for in KRS 311.629. In another section, section 633, it provides, it addresses refusal to follow advanced directives. It may allow hospitals and physicians and staff to refuse to withdraw life-sustaining treatment or refuse to continue providing life-sustaining treatment when it's futile. But the actual text of the statute does not limit the reasons why they may refuse or honor it. So a hospital or a physician may refuse if it believes that that treatment is futile. Interestingly, KRS 311.633 does require nurses and other employees to state their objections on religious or moral grounds, which suggests that this limit could have been imposed on hospitals and physicians, but it was not. That's I don't know why, but that's rather interesting. A couple of, or at least one very important Kentucky Supreme Court case that was decided a few years ago in Woods versus Commonwealth. The Kentucky Supreme Court upheld the statute which allows legal guardians to approve the withdrawal of life support from an adult patient who had not made an advance directive, so long as there is, magic language, clear and convincing evidence that the patient is permanently unconscious or in a persistent vegetative state, and that withdrawing life support is in the patient's best interests. So obviously you can state your preferences in living wills, advanced care directives, but the Kentucky Supreme Court has also upheld the withdrawing of treatment under those circumstances, even for those who have not made an advanced directive. Finally, is on these issues, and then I'll just make a few final comments about funeral expenses. But it's interesting that this year, the Kentucky legislature introduced a bill, House Bill 149, that was called the Medical Aid in Dying Act, Medical Aid in Dying Act. And it only made it into committee, was not voted on, and would, if passed, would make Kentucky one of the few states, but it is an emerging area of law in which the summary for that legislation creates a new section of KRS chapter 311 that I just referred to here, would create a new section to establish that a qualified terminally ill individual, they would have to meet certain qualifications, but if they meet those qualifications, a terminally ill individual would have a right to voluntarily request medication to self-administer to cause death. So it's not technically physician-assisted suicide because it's self-administered, but it would allow an individual to request a voluntary medication to self-administer to end their life. Again, that was not passed. I think I can't remember the number of states. It's a minority of states, but several states have adopted this type of legislation. And so I expect that this will be proposed again in the future, and we'll see where it goes from there. Finally, let me just say about funeral expenses that we've mentioned a couple of items on that topic already, but just finally to say that there, according to the statistics that I was able to see here, that that about 34% of individuals age 50 and over, 34% of individuals 50 and over have done some type of pre-planning for a funeral or burial. But interestingly, only a portion of those, about half of those or so, have actually prepaid for the funeral expenses or burial expenses. Keep in mind that pre-planning and prepaying are two separate things, and many funeral homes or funeral directors will offer both a pre-planning process, which is a lot of kind of what we've talked about here this evening, but also to offer prepaying as well. Now, of course, there are benefits and liabilities to prepaying for funeral expenses. There are, of course, concerns that what could happen if an individual changes their mind or moves, or what happens with that asset. There can be concerns about the financial viability of the funeral establishment, or if all of the expenses have not been paid. Sometimes there's provisions in the contract that can limit the benefits that are received. And so, like any contract, any prepaid funeral expenses should be, it's a contract, and whatever the terms of those contract are is what ultimately will be enforced. Funeral expenses are, under Kentucky law, are considered to be what are called a priority claim in an estate, which means that the funeral home, if the expenses are unpaid, the funeral home has a priority claim to the assets in the estate. Or if an individual has paid the funeral expenses on behalf of the deceased individual, can file a claim and also have a priority claim to the estate assets. So, Philip, that's some information on end of life care and planning, as well as funeral expenses as they relate to estate planning. If there are any questions, I'll be happy to entertain those if I have an answer, or if not, to.
Sure. Greg, I don't know if you got any questions, or if anybody on the chat box has got any questions. I'll go back here in just to check just a second. But one that came up back in your first talk there, you were talking about having some very difficult discussions with family members. Do you have any tips how to initiate those conversations?
Yeah, well, that's as unique, I guess, as the individuals are. Some for me personally, my discussions, and I've had them with family members, both for those for me personally, as well as for those of which I would be the one carrying them out. For me, it's always been, and again, it's a personality thing. It's always easier for me to approach it a little more lighthearted and to try to inject as much reality in it as you can, and realize, of course, it depends upon the stage of the discussions, and again, that's why it's best to have these as early as possible, so that it's not right at the time when the most emotion is going to be at the surface. Obviously, if you're dealing with a new medical diagnosis that is giving a relatively short time for your prognosis, it can be a very, very difficult conversation. And sometimes those are best had to just to do them directly, as the saying goes, to bite the bullet and have the put it on the table. And And sometimes, you find that once you broach the topic, that it may not be as difficult as you thought it might be to at least get the conversation started.
Well, thank you, sir. I have no more questions. April, do you have anything that you need to wrap up with?
No, sir. I
All
think
right.
I'm good.
Well, that'll conclude the estate planning sessions, and everybody have safe trips back to your home if you're at the extension offices, and happy holidays.
Thank you.